Professor Josh Blackman from South Texas College of Law, and he's going to be talking about 3D printed guns. I'll let him get right into it. He's going to talk for 35, 40 minutes, and then Professor Lash will give a couple comments for 5 to 10 minutes, and then we'll open it up for questions after that. So here's Professor Blackman.
You know, I was waiting for a long interest, like a chew. Oh. Thank you so much for having me. It's a pleasure to be here. My first time at Richmond. I've never been to this college before, so it's a pleasure. Also, my dear friend Kurt Lash, he is an expert on all things reconstruction. If you haven't taken his courses, I recommend you do it because he knows the stuff. I saw him do a presentation recently. He will give you everything you need to know about the 14th Amendment. My talk is a little bit more boring. The topic today is 3D printed guns. And I have a treat for you. You get not only one constitutional amendment, you get 2 constitutional amendments. How the First and Second Amendment interact to protect the right to 3D printed guns. So, oh, is this thing gonna work? Yeah, perfect. Who here has ever actually used a 3D printer? Okay, a couple people. What'd you make? A what? A cosplay gun. Oh, a fake gun. That's actually very useful, right? Let me stick on that one for a minute, because I used this hypothetical in court once. So if you didn't hear, she said her friend made a cosplay gun, which is basically a non-functioning firearm, used for like comic book conventions, right? Now, let me ask you a question. Let's say you design the blueprints for a fake gun, right? It's a toy, can be used in a Comic-Con or whatever else. And then you give that blueprint to someone else. And then they modify that file so it's no longer just a fake gun, but it's a real gun. And that person then prints that weapon, and maybe the state doesn't allow them to possess a firearm. Can you be held liable under criminal law for giving someone the files needed to make a gun, even though your gun was a toy? That is the exact case that I've been litigating since 2014, right? I represent Defense Distributed and the Second Amendment Foundation. Defense Distributed is known for putting files on the internet that can be used to make firearms. Now, their guns were real. These weren't toy guns they're putting the blueprints for. But recently, New Jersey enacted a law. And this law makes it a crime to share information on the internet or anywhere of information that may be used to make a gun. So I was in court about 2 months ago, and I made this argument to a judge, and I said, Judge, under the New Jersey law, it's a crime to put online a file that can be used to make a toy gun, because that gun may be modified in certain ways to make a functional gun. What we're talking about here isn't the right to actually possess a plastic gun, and that's not what this talks about. This talks about the right to share the information needed to make a gun. Now, what is 3D printing? How does it work? You begin by designing a file on CAD. What's CAD? Computer-aided design. It's a way of developing information on a screen, not by hand. You can design a car, you can design a house, you can design many different complicated objects, right? It all operates using code. Now, I take it some of you have been involved in coding in your careers, right? Coding is a way of expressing ideas using formal statements, right? The same way if you want to plead a complaint, right, you gotta follow Rule 12. Computers work in very similar fashion. If you want to design an object on a screen, you got to follow rules. So for example, let's say you want to create a cylinder, right, basically a tube, with a height of 20 inches and a radius of 5 inches, right? You write the code. Cylinder, H, height, is 20, R, radius, is 5. Using these simple rules and simple words, I just showed you in 5 seconds, you too can develop the code to make a tube, make a cylinder. Okay? And 3D printing lets you make a wide range of objects. Toys, trinkets, race cars, anything. Now, let me show you how 3D printing actually works. Has anyone ever made a candle, right? How do you make a candle? Okay, you take a wick, right, a little string, and you dip in the wax, you pull it out. You dip in the wax, you pull it out, you keep dipping it over and over and over again. And every time you dip it, it gets a little bit thicker around the base, right? That's how a candle works. 3D printing functions in a very similar fashion. But instead of dipping a wick into wax, you spray a very thin layer of plastic. It's liquid. You put one layer, you put another layer, you put another layer. You stack the layers on it. So here you can see they're printing a little ball, right? And the ball's not quite finished, it's flat on the top. If you keep putting one layer on top of the other, you can create a three-dimensional object. This picture shows another method where you actually have a heated bed, where you put down this sort of a liquid plastic and it heats up and eventually it cools off and it makes a solid figure. All right, I want to show you now a demonstration of 3D printing an object. Kurt saw this right, so don't volunteer. They're printing an object. I'm not going to tell you what it is, but I want you to guess when you can see it, okay? So the first step is this basic honeycomb lattice, right? This very basic structure. This is the base of the object. So you have number one, number two, number three. Anyone see it yet? Number four. Anyone see it yet? What? Frog, you're on the right track. On the right track. This is number four. Number five. Anyone see it? Think about it. It's a bust. Good. Six. Anyone see it? Oh, people usually get it number six. Yeah? Well, they're both wise, I'll give you that much. They both have good sayings as well. Seven? Oh, come on, Richmond. Oh, boy. Yoda! Thank you. Yes, it's Yoda from Star Wars. He's very wise, good sayings. Okay, that was a hint. Okay. Yeah, it's Yoda. 8, 9, 10, 11, 12, 13, 14, 15, 16, done. Ready? Done. You can create a fully functional device, a fully functional bust using this technology. Now, I am not artistic, so I went to law school, right? If you gave me a piece of clay or a block of stone or a piece of wood, there is no universe in which I could make that object by sculpting it. Look, guys, I just can't do it. But I'll tell you what, if you give me a computer and some code, I can whip that together in pretty short order. That is the promise of 3D printing. It allows you to develop ideas in your head, design them on a screen, and then this device translates them, with your help, into reality. So, of course, what do Americans want to make? Yodas? No. Guns. And one of the first controversial uses of 3D printing became the manufacturing of firearms and a gun known as the Liberator. Now, this is the blueprint, the schematic of the barrel of the Liberator. It's a pistol. Now, you may not know a lot about guns, that's fine. The way a gun works is you have a bullet, you strike the back of the bullet, it goes boom, and then the projectile flies through the barrel of the gun, right? Pretty simple stuff. This is the barrel of the Liberator. The bullet comes out of this little hole. Now, I played a trick on you before. I showed you the code used to make a cylinder. The barrel of a gun is a cylinder. You now know how to make the barrel of a gun. I'm an insurrectionist, I know. But the point is, it's not that complicated to actually design these parts. You could do it probably with a few hours of study. The hard part is actually making plastic that won't blow up in your hand. Plastic is an awful way to make a gun. Okay, why? Steel, good. When steel gets hot, it expands, and when it cools down, it contracts, right? It's a very unique property of steel. It's perfect for weapons. Plastic, when it gets hot, it melts, and when it gets cold, it cracks. This is an awful way to make a firearm. In fact, when they first started making this weapon, it would blow up in people, well, they would put it in their hands, but they blow up in dummy hands, right? It was not safe. So, bad way of making a gun. But this is a Liberator. Okay? You want to know what this is? Come on, yeah. Very good. It's a lower receiver for the AR-15. This is the guts of a gun. This is what actually makes the AR-15 work. This is the only part the government cares about. Believe it or not, under federal law, if you buy one of these, you have to go through a background check. If you make your own, you don't. So 3D printing allows people to make their own lower receivers for the AR-15. They also developed magazines, as well as this. What the hell is this, Josh? These are the parts of the Liberator separated. These little squigglies, those are the springs used to pull back the trigger. This blue thing is the handle. This is the receiver. That's the barrel. That's a bullet, and that's a nail. Why is there a nail in there? The nail is used to hit the back of the bullet as the firing pin. That's what actually makes the gun operate. This is what the Liberator looks like fully assembled. You can see there's a little rope over there. The reason why they have a rope is when the gun was first being developed, it was very fragile. They wouldn't pull the trigger by hand because you might lose a finger. So instead, they put a rope on the trigger and stand several feet away and yank it to test it. And many of them did blow up. But eventually, they developed the science, and Cody Wilson, who was a law student, figured out how to do this. Well, so what? Is it a crime under federal law to make your own weapon? Short answer is no. I'm not talking about state law. Some states have started to get involved here, and I think those laws have some other problems. But as a matter of federal law, there's no crime to make your own weapon. Okay? But this is not how 3D printed guns work. It's a little bit different. Okay. So, I want to talk about zip guns for a minute. Anyone ever make a zip gun? You know what it is? Okay, a zip gun is a homemade weapon you can make on your own. For example, I found this beauty on the internet. It's a soldering iron and a garden hose. I could go to Home Depot right now. Give me $10, I can make a gun. 3D printing gun is possibly the stupidest way of making a gun. It's expensive, it's time consuming, they're not very effective. This, soldering iron, garden hose. I found this one on the internet. This one's good. It's a keychain flashlight, which was repurposed to be a gun. All you need to make a gun, my friends, is something long that can withstand a combustion. That's it. Now, I want to show you a demonstration. Okay? Do not try this at home. Please do not try this at home. These guys are going to make a rifle out of a rubber tubing and a metal pipe with a shotgun shell. And they have a flip phone, so you know this is legit, right? This is credible, right? So the video is a little bit old, and actually, I can't play the video. There's a lot of cursing, so I'll just show you stills. But the video is pretty. You can find it on YouTube. It's pretty bad. All right, so okay, they're gonna make a rifle. How? On the edge of this metal pipe is a little dimple, and when you strike the metal pipe into the back of the shotgun shell, it will trigger the charge, go boom, and send the projectile forward. Okay? So here's what's going to happen. They're going to load the shotgun shell, the red thing, into this rubber tube. And they're going to jam it. Now, I want you to look very carefully at this picture. What's wrong? Kurt's laughing. What's wrong with this picture? Yeah, okay, so his hand's in front of the gun. Okay, good, number one. Number two, what else is wrong with this picture? Yeah, his other hand's in the back of it, good. What else is wrong with this picture? Yeah. Oh yeah, big problem, right? But there's an obvious problem. What's problematic about this entire little experiment? They're indoors. They're inside. And it gets worse. Anyone see this? Here, I'll show you the next picture. It's a little bit more clear. They're firing into a cardboard box which has several holes. So they've done this before, obviously. And there's electrical cable coming down, plugging into this fan. Again, idiots with guns, right? Okay. So they're going to fire. Ready? 1, 2, boom. They didn't kill themselves. Congratulations, right? They have all 10 fingers. But they made a fully functional firearm with about maybe $5 worth of parts from Home Depot. These are things which you could check on a plane pretty easily. Okay? And here they are bragging and boasting how cool they are. See the smoke coming out of the shell. Yeah. Okay. Did they break the law? Under at least federal law, the answer is no. Under ATF regulations, it's alcohol, tobacco, and firearms. There is no problem with making it your own weapon. You can't sell it. No, let me be very clear. If you sell it or convey it, you need a license, which is very difficult to obtain. But if you make it for yourself, you're fine. Why then am I in court, right? What's the problem? There's no federal law banning the printing of the guns. There are laws banning felon in possession, which are a little bit different. But the reason why we're in court is not really because of the Second Amendment. It's because of the First Amendment. The basic tenet of the First Amendment is the government cannot impose what's called a prior restraint of speech. That is, the government can't make you get permission before you speak. They might be able to punish you after the fact. So let's say you engage in defamation or libel or something like that, right? They might be able to punish you after the fact. But it's a pretty well-accepted rule in our courts that the government can't make you a permission before they speak, especially when that permission is based on the content of the speech. Right? That's what's known as the doctrine of prior restraints. Okay? And this doctrine applies even where the speech might be, shall we say, dangerous. Consider the Anarchist Cookbook. Right? This is basically a manual to be a terrorist. I'm not exaggerating, right? It tells you how to do really bad stuff with common kitchen items that you find in the hardware store. Back in the day, governments tried to keep the Anarchist Cookbook off the shelves, and the courts said no. Right? The mere fact that speech may be used by someone to do bad things is not permissible. Now, maybe, let's say I give you step-by-step instructions on how to assassinate someone. Right? I say, here's where you find them, here's what you do, step-by-step. I can be charged an accomplice to murder. I think that's okay, because I have a specific intent, and there's a very close fit between my speech and the ultimate crime. But merely publishing a book or information of how to build a gun, I think is far too attenuated. There's way too much of a gap. Now, you might ask, wait a minute, Josh. We're talking here about books, but you have code, right? Is code speech? And this is an issue that the courts have started to, I think, grapple with. And by and large, most courts, this is not Josh talking, most courts have held that information in the form of code can be speech. There are different kinds of code, and I don't want to bore you with it, but the type of expressive code I showed you before, which can be understandable to the human eye, I think falls in a line of code that should be protected. And code is everywhere. And even the Supreme Court recognized in a case called Strel v. IMS Health that the creation and dissemination of information are speech, right? It's not just about books, video games, movies, and the like are protected, right? We live in a world governed by code. All right, so that's the First Amendment. I also promised you to talk about the Second Amendment. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Right? This is the Second Amendment. What does it actually protect? Well, as of now, the Supreme Court's not said much. All they said in a case called Heller is that you have the right to a gun in your home. And then a follow-up case called McDonald, they said that the states also can't violate this right. The court's been pretty silent about the Second Amendment. But at least we know that the DC and the Chicago handgun bans are no more. So what does this actually mean then? Well, I think that there are two facets of the Second Amendment that are worth discussing, right? The first is what I call right to acquire arms. And let me give you a hypothetical, right? Actually, it's not hypothetical. A person running for president from Texas, rides a skateboard occasionally. He recently made a comment that he said, okay, if you have an AR-15, that's fine, we just won't sell any new ones, right? If you have a gun, you can keep it, right? You have the beta version of the gun, but you can't buy a new AR-15, something like that. I use these hypotheticals and people actually say them, they become real. Is that a Second Amendment violation, right? That if you have a gun, you can keep it, but you can't acquire a new one. I think that's problematic, because that means if you're under 18 or under 21 and you weren't old enough to acquire at that time, you are forever barred from carrying one of these guns. I think at a minimum there's some right to acquire guns. I think it can be regulated. I'm not saying no background checks, that's not my argument, but there's some right to acquire guns. They can't just ban the possession altogether. Okay? But I also think you have a right to make arms. And I'm actually much more confident about this, right? I'm speaking here in Virginia. Many of our proud revolutionaries came from here. Back in the day, if you wanted to overthrow the British government and you wanted a musket, you couldn't go down to Walmart to buy it, right? You made your own damn gun. And there's a very long tradition in this country of gunsmithing and making your own musket, and making your own rifle. And I think a facet of this is actually a constitutional right to make your own weapon to suit your own needs. Now this is not, Josh, I want to make a plastic gun because I want to evade metal detectors. Let's say you have a disability and you can't fire a bullet with your finger. You want to use your foot. There are guns. You can modify them for people with disabilities. They can actually trigger it with different parts of their body, right? Let's say you're not a righty. Let's say you're a lefty. You want to change the grips. There is a very long tradition of gunsmithing, and to this day, it's not illegal. So long as you make the gun for yourself, federal law is no problem. So where does this leave us, right? I think you have a right to acquire arms, and you have some right to make arms. This gives right to what some courts have called a hybrid right. I'll give you an example. Let's say the government passes a law that says it's a crime to wish someone a Merry Christmas, an actual war on Christmas, right? Is that a violation of free speech? Or is that law a violation of free exercise? Or both? I think it's actually both, right? You're stopping someone from speaking about their religious practice. Here, what's actually going on is the government is stopping you from speaking about how to bear arms, right? They're censoring you of how to exercise the right to bear arms. So it's actually the First and the Second Amendment working hybrid. And maybe you don't like that example, I'll give you another example. Let's say the government passes a law that makes it a crime to publish books on how to perform an abortion. Is that a violation of the due process clause or that free speech, or maybe it's a little bit of both? When the government stops you from speaking about another right, there's a reinforcing aspect that I think triggers even higher scrutiny, right? They're stopping you from speaking and exercise your right to bear arms. Problematic. Okay. What are the federal laws in the books now? There's a bill called the Undetectable Firearms Act. This bill was passed in the late 1980s. And it says that all weapons must have a certain quantity of metal, right? You can't have a gun that will pass the metal detector undetected. Okay. The Liberator, as it's designed, has a block of metal in the handle. I always get the question, the metal is non-functional. It's there solely to comply with this law, but it does have this block of metal. Now, we ask, wait a minute, Josh. If this law was passed in the 80s and the plastic gun came out in 2013, what were they thinking about? Undetectable firearms are not new. Back in the 80s, there was a very big concern about the Glock, which is a fairly popular handgun. And there was a fear that these Glock handguns may have plastic and people go through airports and metal detectors. Well, why do you have this fear? Well, this fear was reflected in the Die Hard movie, right? You know, today Congress, we ban stuff because what's in movies. Here, maybe it happened, right? Bruce Willis, one movie, said, luggage, that punk pulled a Glock 7 on me. You know what that is? It's a porcelain gun made in Germany. It doesn't show up on your airport x-ray machines, and it costs more than what you make in a month. Every facet of that statement's false. Every one, right? There's no Glock 7. They're not made of porcelain. They're made in Austria, not Germany. It will show up on an x-ray machine, and they're fairly affordable. But people still have this panic about plastic guns, and it goes way back, even before 3D printers were in common usage. Okay. Several states have tried to ban 3D guns. In fact, Congress, Senator Schumer tried to ban something else. He was not successful. But New Jersey and some other states have tried to actually ban these devices. Okay? You might say, wait a minute, Josh, maybe we need to ban the plastic used to manufacture these guns. Guess what, folks? You can 3D print metal. Yes, this is a 1911 handgun made entirely with a 3D printer. Like Terminator, right? You can 3D print metal. So I think it's going to be a huge difficulty to actually prevent this, at least through traditional means. So how did the government come after us? Well, shortly after Sandy Hook happened, in 2013, the Obama administration instructed his entire cabinet, I want you to find ways that we can restrict guns through executive action. Right? Before Trump had a pen and phone, Obama had a pen and phone. And one of the ways they tried to come after us was through export control law. Now, this is something that you probably have never even heard of or studied, but it's called the ITAR. It stands for the International Traffic in Arms Regulation. If I want to send, I don't know, a Stinger missile to Afghanistan, I probably should get the government's permission first. That makes sense. If I want to send the blueprints for a nuclear submarine to China, I should probably get the government's permission first. I think we all agree that makes sense. I don't have any problem with those rules. But the Obama administration said that this ITAR applies not only to, classified information, but also speech in the public domain. Open source files that have been shared millions of times. The government never before applied this export control regime to publicly available information. It was the first time this had ever been done. And they sent a letter to Cody Wilson in 2013. And this letter said, without any hesitation, you are in violation of export control law. By putting a file on the internet, you are exporting information to our adversaries. Why? Because people in foreign countries can access the internet, shock, right? And they can download your files. Now, Cody thought he was just putting stuff on the internet. He didn't intend to send it to China or Russia or anything else. He was simply putting it online. They demanded the information should be removed from public access immediately. To take down notice from the government on the internet. This had never before been done. And this triggered an almost 5-year litigation battle. And I want to summarize it briefly, because every time I give this talk, it keeps getting a little bit longer and longer and longer. Let me give a brief summary so Kirk can get ready for his rebuttal, or response, or rejoinder, or his commentary, whatever he wants to call it. So he doesn't lash out at me. Sorry. It's terrible. At least I'm not Randy Barnett. We filed suit in 2015, right around the 2-year anniversary, which is our statute of limitation. And we sued the State Department. And we asked the federal government to enjoin the State Department policy, which we argue was a prior restraint of speech, violated due process, and other sorts of things. The district court ruled against us. He denied our preliminary injunction, and we appealed the case. The Fifth Circuit ruled against us, but on fairly narrow grounds. They said that there's a risk of irreparable harm because there's a preliminary injunction, but maybe come back on summary judgment, we'll look a little bit differently, right? You always have 2 bites of the apple in litigation. You first seek a preliminary injunction. If you lose that, you can come back and seek a summary judgment, which you probably studied in CivPro. We had 1 dissenting vote, Judge Jones in Houston, who was very vigorously on our side, but she was just 1 vote. We then petitioned for a hearing en banc. We got, I think, 4 or 5 votes on the en banc pool, but we still lost out. We filed a cert petition. The cert petition was denied. All the work that goes into a Supreme Court wasn't interested yet, which made sense. It was only a preliminary injunction. Then we went back to the district court. And the district court ordered the parties to engage in settlement talks. And we were actually optimistic because we realized, they barely won on the PI motion. I think we had a good shot at summary judgment, and the government agreed. They agreed to settle the case with us. They agreed to give us a license to publish these files, and also to modify their rules such that other people could share these files as well. All was good, right? The client agrees, the government agrees, you're headed for a settlement. Nope, we would not get there. I mean, this gets pretty brutal. So this was over this past summer. The district judge, the settlement was to go into effect on Friday. Okay, settlement on Friday. On Tuesday, we get this emergency motion. Gun control groups tried to intervene in our case to block our settlement. The Brady campaign, Giffords, and Everytown, all these other alter egos of Michael Bloomberg, they tried to jump into our case to block our settlement. So on basically no notice, I had to argue this basically a TRO motion. I argued the first one. I prevailed. I said, Judge, they have no interest here, deny the motion to intervene, fine. Okay, so this was Friday afternoon. I argued my first TRO in Austin. At that point, we had our license. We had what we needed. Cody wasn't supposed to post the files till, I think, Tuesday. I said, Cody, you post those files right now. Put them online immediately, because I don't know what other crap is coming this weekend. We didn't know. I said, Cody, put the files online now. He did it. That night, the files went online. We won. They were in the public domain for 3 days, but they were in the public domain. At that point, we started strategizing and said, wait a minute. These states, these people are going to sue us, right? We already had some threatening letters from New Jersey and other states that said, let's go on offense. Let's sue New Jersey in federal court and seek a 1983 judgment that they're violating our rights. So all weekend, I was frantically preparing a complaint to file against New Jersey District Court in Austin. About 30 minutes before I hit submit on the filing system, I get an email. Pennsylvania was seeking an ex parte TRO against us in District Court. Ex parte means without any briefing. They want the judge to enter by himself. On a Sunday afternoon, I was supposed to be flying back to Houston. The judge schedules a hearing by phone within 2 hours. I actually argued my second TRO by phone from the United Lounge at LaGuardia Airport. Probably possibly the worst airport in the United States. It was loud, it was noisy. I'm like, oh my God, this is terrible. I actually defeated the TRO. I actually kind of prevailed. Not fully, but I got enough what I wanted. So I was like, okay, Josh, feeling good. But we knew more was coming. Then we filed the suit against New Jersey. The next day, New Jersey sued us in New Jersey Chancery Court, right? It's basically a limited court of equity, right? So if your neighbor is playing loud music and you want to get an injunction to stop the nuisance, that's the court you go to. New Jersey sought a nationwide injunction against us in a chancery court. My goodness. So I had to argue that one by phone as well. I was in a million places at once. And I actually told the judge, this was a little ballsy, I said, the judge, Your Honor, with all due respect, I don't think you have the jurisdiction to issue a nationwide injunction. And he said, I think you're right. Okay, so we actually prevailed there. Personal jurisdiction was a mess, right? But then we got sued by eventually 20 states, right? The AG of Washington State, sued us in District Court in Seattle. We had no business in Seattle. We had no business there. And he asked the judge to block our settlement. Now, you may have not taken administrative law yet. Maybe you will, Professor Walsh or someone. Can you teach admin? No, at least Fed Court's good. Anyway, they argued that our settlement violated the Administrative Procedure Act. Let me get to it again. That the decision of the government to settle a private case was an arbitrary and capricious action under the APA. I had to argue that one also. And I argued, Judge, you are about to impose a prior restraint on millions of Americans to say that they can't post these files. These files are already on the internet. They're out. They're gone. You can't put them back. The judge in Seattle asked me one question during my argument time. He asked me, Mr. Blackman, do you represent all the parties? I knew I was going to lose, right? When the judge says you represent all the parties, it means we're going to rule against you so we can give a judgment to everyone. He announced from the phone his ruling, and then he had a written opinion afterwards. He says, I rule for the state of Washington, you lose. Then I had to call my client, which is never a good call to make. And we had just gone through a roller coaster. I think I worked 90 hours in 5 days. It was insane. And I called Cody and I said, Cody, take down the site. And he's like, okay. And I was crying. He was on the verge of tears as well. And it's not easy. He built a lot of redundancies to make it hard to take down the site. So actually removing it was a lot of work. And he then took down the site and he removed all the files. And 6 months later, we're still in litigation. We're still litigating in Washington. We're still litigating in New Jersey. We're still litigating in Texas. We're still litigating in Pennsylvania. We're all over the place. But this has been an amazing experience from start to finish. One that I think the Supreme Court will eventually have to take, because we probably will get a split on something. And at that point, we'll maybe get some clarity from the court on the intersection of the First Amendment and code. I'm going to stop there and turn it to Kurt. But this has been a fun experience, and I very much enjoyed sharing with you. Thank you all so much.
Well, Josh, it's great to see you. And my thanks to the Federalist Society for putting this on. Josh is extraordinary. You know, I appreciate the compliment that I know about the 14th Amendment. If I started listing the things this guy knows about, you know, we're done for the hours. And he's not just an extraordinary scholar, he's one of the most influential law professors, academics, and lawyers on the internet. I suggest you all follow him. No, seriously, you'll be up. You'll be up on what's happening in the courts. So thank you. Thank you for honoring us in coming here. I'll have three quick thoughts, okay? And I suppose they are challenges to a certain degree, but not too much. More questions of clarification. As far as the, quickly on the Second Amendment issue. And I presume because we're fighting states, we're going to be under the 14th Amendment, right? Okay. For those of you, this is now in my ballpark then, you'd be talking about Reconstruction and Reconstruction rights and the rights of the freedmen to obtain armed self-defense weapons after the Civil War. I think you have a very strong 14th Amendment claim under the Second Amendment. One potential problem and something to think about is that you seem to be making the claim that it's not just the right to keep and bear arms, but the right to manufacture, and not just the right to manufacture, but the right to any means of manufacture. There you're going to get some pushback, right? Because even in the abortion area, there are regulatory restrictions in the manner and the facilities. I know that's in litigation, what counts as an undue burden. But it may not be the case that even if you get a ruling from the court that there is a right to manufacture weapons under the 14th Amendment that necessarily involves this particular technology. Okay, so that just that's going to require another level of argumentation. As far as the First Amendment is concerned, there are two issues there, and you hinted at both of them in your talk. One issue is, if this is speech, is it speech of such dangerous characteristics that it is subject to government enforcement, either by way of a TRO or punishment after the fact. And you're right, TRO is especially difficult. Prior restraint is particularly difficult to get. Even punishment after the fact is particularly difficult after Brandenburg. There has to be direct incitement of imminent lawless activity, which is likely to succeed. It has to be even higher if it's going to be a prior restraint. But here you're facing an interesting Supreme Court, and I think there might be room for pushback against the Brandenburg standard. Prior to Brandenburg, there was the Dennis case back in the McCarthy, the so-called McCarthy era, where the court, it was a fractured court, but the lead opinion indicated that sometimes we don't use a clear and present danger test, which ultimately becomes Brandenburg. Sometimes we don't use clear and present danger if the danger and the risk is of such a height that it suggests that we should relax the requirements of imminence. Right? So the greater the danger, the less the requirement that that danger actually be imminent. If the risk is an atomic bomb that's going to explode, then you lower. You don't care if it's directly imminent, but it's maybe within 2 weeks it's going to blow up. Within 3 weeks, you're going to give a little bit more flexibility to the government. This may be a situation due to a brand new technology that even if we consider this communication and consider it speech, you might find 5 justices on the court who would be willing to reinvigorate the Dennis standard, saying that this has such a potential for flash fires, because once it gets on the internet, it's out. That this new technology, due to the danger of this new technology, that it actually requires a different test, and one that's more forgiving in terms of government enforcement. And here, I would suggest that Alito might be your problem, because Alito in the violent video game case, right, in Brown, Alito also suggested and looked towards the problem that new technology can create new problems and new dangers that don't fit under general common law standards of freedom of speech. So you might be facing a danger there, that a new technology could convince the court to create another test. And so you would need to make an argument about why we shouldn't fear this as a particularly dangerous technology, or about why it shouldn't matter. That's point number 2. And then lastly, is this speech at all? Right? And you talked about this briefly, and I'm not real sure about how this works. Excuse me for a second. There we go. Is that speech? I'm taking an action here. There's code, there's computer code, right, that communicates. By the way, that's a metaphor. There's no real communication going on at all. It sets something in motion, which requires my phone over there to tell me, you left it over here, stupid. That's what's actually going on here. It's a special little find your phone thing, okay. What's different about what I'm doing than entering code, which then triggers an action on the part of a 3D printer to produce a sound, produce a gun? Where's the speech that's involved here, right? Isn't it possible that if you're talking about communication to a machine, you're not really talking about communication at all? There's a lot of anthropomorphism going on here in terms of we are communicating, we are informing, we are sending information. None of that is really taking place at all. There are O's and dashes and ones and zeros, and there's human activity, but there isn't really communication. And I think that you'll find is code actually speech? Without having looked at those cases myself, I bet it involves code that creates actual speech, maybe books, maybe presentation, maybe art, maybe something that actually involves a communication to a human being. Isn't it possible that in this case, when you're talking about actions which call into play mechanical reaction and nothing else, isn't really speech at all? Those are questions, those are issues. I want to leave time for everybody else to talk, but thank you. Thank you for coming.
Thank you so much, Kurt. I think his little watch doohickey zeroes in, no pun intended, on an important point. Not all code is speech. I think there's a line to be drawn. Now, when Kurt pushed the little button on his smartphone and it triggered the location, it was an entirely automated process. He pushed the button and it sent signals to the air. The sort of code we have at issue is not automatic. There's a lot of human judgment and interaction that goes into printing the device. What kind of materials you use, the dimensions, the proportions. It's not just point, click, shoot. If we had a point, click, shoot, I think the analysis would be different. But the sort of expressive code we have, which can be represented graphically, is different. This code's been displayed in museums. Architectural students have studied it. There's a lot of value separate from code. Now, I take Kurt's question very well. Justice Alito in the video game violence case said when you have this developing new technology, maybe we should be more deferential to the legislature. And then Justice Roberts and Justice Alito had a concurring opinion where they said rather than striking this law down in overbreadth, we should strike it down on vagueness grounds. And I'm okay with that also. The New Jersey statute we're challenging is quite vague. It imposes criminal liability if you develop code that may be used to make a firearm, that's the cosplay gun, toy gun, or even code that may be used to make a firearm component, like a nut or a bolt. So if I put on blueprints online of how to make a screw that can be used in a gun, I'm now liable. So I'm okay with the Alito approach in Brown v. EMA. I conceded to the court there might be a way of drafting a narrowly tailored statute that addresses a more imminent threat. But the law you have now is so far attenuated. It only bans the sharing of the code. It doesn't even ban the possession of the code. So you have over-inclusiveness and under-inclusiveness problems. So this statute, I think, falls on a lot of different grounds. This should be a 9-0 case. Probably won't be. That should be a 9-0 case. Now about the 14th Amendment. We haven't actually asserted the right to print the gun, and we're actually very careful about that. We haven't said that there's a right to print whatever gun you want, whether it's plastic or otherwise. I don't think under Heller you have a right to a plastic gun without a serial number. I don't think that works under Heller. Maybe Heller's right, wrong, I don't know, but I'm going to argue under Supreme Court precedent. But I do think that the right of self-defense does kick into it. And to the extent that you can make a weapon that suits your own needs, this I think is a viable technology to do this. And I'm not being facetious. There are a lot of people who make guns to meet specific physical needs that you can't go to a store and buy one off the shelf. This is actually a non-trivial concern. I think that's good enough for now. Maybe Q&A, does that sound right? Okay, I want to hear from all of you. Thank you. Thank you, Kurt. And any questions? I know you have class at 1, so I'll be judicious with finishing on time. Thank you. Yes? Yeah. 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 Yeah, yeah. Yeah, well, there's a lot of good stuff in that question. Let me try to address it one point at a time. Generally, when the government wants to ban something, they ban the end product, not the means to get there. And that's important in the free speech context, right? You need the least burdensome, the most narrowly tailored way of addressing a problem. Now, your hypothetical about the book is well taken. This code actually exists in a book, right? It's printed. I have a copy on my bookshelf. We actually submitted this book to the court under seal. What? We argued that if we were to put the PDF of this book online, it would violate New Jersey's law. So we actually, a little bit of a smart aleck, but I think it makes a point. We actually sent a sealed copy of the book to the court to hold in the court custody. During the oral arguments in the Fifth Circuit, one of the judges asked, what happens if this code was published in a book, would the government object to it? And man, the lawyer would not answer that question. Because the lawyer knew for DOJ, if your answer is yes, you can ban a book, you're going to lose. So he wouldn't answer that question. There was the Citizens United case you probably studied in con law, a very famous incident where Justice Alito asked the DOJ lawyer, instead of making a movie about Hillary Clinton, let's say they published a book about her, could the government prohibit the publication of that book in a certain time window? And the lawyer said yes. Wrong answer. So then Justice Kagan, she was a Solicitor General, argued the case a second time, said, no, we're not going to ban books. Her answer was incoherent. There was no reason why a movie you can ban, but a book not. But I think when you start thinking about, can you ban a book? You're in trouble. Okay, other questions? Yes, sir.
So then would you accept a law that, a state law that prevents the use or printing of a 3D gun that doesn't detect?
Okay, so let me give you my position. I've answered this question before. I think a state could require a firearm to have a certain quantity of metal and have a serial number. So long as the serial number is issued in an expeditious fashion, right? It can't be, well, you can ask for a number, we'll never give it to you. If there's actually a meaningful opportunity to make your own gun, it complies with the Federal Undetectable Act and has a serial number, I'm okay with that. Now, if they say you can't print your own gun, even with metal, and we'll never give you a serial number, then I think there's a problem. I think you have some hell of problems there. But so long as the serial number can be given in an expeditious fashion, I'd be okay with it. Yes, sir?
So it should change right now.
Again, so the premise of the question is an automatic weapon. Under federal law, generally you can't possess an automatic weapon. Our First Amendment claim doesn't turn on the Second Amendment, but it's helped by it. So to the extent that we're here printing the Liberator a pistol, which is the quintessential weapon in hell, I think our claim's stronger. If you're trying to print an automatic weapon, I think the claim in the Second Amendment is weaker, but the First Amendment claim still works. I mean, look, most people who download this code never actually make the gun. Right? It's never actually printed. People just do it for fun and for studying and for thought experiments. So I don't think it invalidates the code altogether. Yes, in the back. Thank you. Yeah. Oh, absolutely. If you talk to a programmer, they'll say their code is poetry. I had a student yesterday, I was at UCLA last week, he said, my code is my poetry. Okay, right? People express themselves in different ways, right? You can write a sonnet, or you can write a syllogism, or you can write a strand of code. If you do have the one input, one output where it's just point, click, shoot, the same way, if you go to a gas station, right, and you press a button, and it mixes the milk and the coffee and the sugar and it makes you automatic coffee. I think it's hard to argue you're engaging in expressive activity there. That's like Kurt's example with his smartphone watch, right? But if you're spending time designing this code, editing it, modifying, deciding how you want to print it, there's human interaction that I think is warranted protection by the First Amendment. That's what we focus on. A very good question. Thank you. Any other questions? Oh, yeah, go for it. Please. Oh, yeah. So if you're the developer who actually programs the algorithm to mix the elements, I think that does have expressive content. But the end person who presses the button, I don't think that's expressive activity. But very, very good question. Yeah, Kevin? Yes. Yeah, how you thought so?
I mean, I'm not sending it to China. I'm just making it available to the whole world, including China and Ukraine and Russia, whoever it is. I mean, you were just defending that on pre-program, or were you saying no as a matter of the statutes and the regulations, this is not exported?
Well, yeah, let me make 2 points. So this regime was drafted during the Cold War, when the only way to share information was by either mailing it or courier. So it's not a good fit for the internet. But they've argued it's a strict liability offense, right? If anyone who's not a U.S., not just overseas, if I gave this presentation here and one of you was a foreign student, maybe on a student visa, I would actually have to ask you to leave the room because I just engaged in export of information because I described this technology. As being hyper-literal, but it's true. It's a strict liability offense. If I am sitting in a Starbucks in D.C. working on a file, and someone from the embassy walks across the street over my shoulder, I've just engaged in an export under the government's definition. It's a strict liability offense. I'm willing to entertain this definition for classified information where you have a secure space, but not for stuff on the internet. It's far too capacious. And there are actually OLC opinions cited by Ted Olson, who's a big lawyer in the Reagan days, suggesting that you can't apply this State Department regulation to public speech. This is before the internet, but she said just academic conferences, right? If I have an academic conference, I shouldn't have to check passports when I'm giving a paper in an American college to see if there are any foreign persons if I'm discussing this sort of control technology.
I'm trying to think of where else this comes up, where you have an older team and then you have new technology. So
Thanks, Kurt.
coordinating expenditures was a case where people had Twitter accounts and they were posting their private polling information. Right? They're saying we're not coordinating together the campaign because it's Twitter.
Yeah.
It's out there in the whole world, and I'm trying to think where else this is coming up with the internet.
I don't know. I'm not sure, but it's a good question. Okay. Anything else? Get to class. Thank you all so much. Thank you.